Hello, welcome to today's immigration tidbit. Well, that's a good sign that his case was sent to the NVC. But you use the word approved. It's really not approved until he has the green card in his hand or he has the I-551 stamped in his passport ready to come to the U.S. There's lots of things that could happen between now and then. However, I'm assuming you're a U.S. citizen or lawful permanent resident. The case is current, unless you're, a U.S. citizen, in which there's always visas available. Once it's transferred to the NVC, their job basically is to get all of the affidavit of support type documents and so forth, and the actual immigrant application, which you assumably submitted. And then what they do is they will forward at the appropriate time the petition onto the U.S. consulate or U.S. embassy, which has jurisdiction over where your husband lives. It will then go there. So I don't know where that is. Let's just say it's in, Venezuela. It then goes there. The Venezuelan consulate, or wherever he happens to be, will then open a case and send notification regarding the opening of that case, and they will require further documents. And then what will happen is they will then set an appointment for an interview, at which point he will go for the interview and hopefully not be inadmissible. And then if everything's approved, he'll get the approval and be able to come into the U.S. as a lawful permanent resident. He will just get a 551 stamp on the passport showing entry to the U.S. is okay as a resident, and then a few months later we'll get the physical green card. So that's the basic procedure. But if I were running this case, I would need to know beforehand at this point if there's any inadmissibility issues or any deportability issues or removability issues, because it can go smooth as butter up until this point, until something happens at the consulate. As a matter of fact, there's cases where, for example, there's no crime, no deportation, no removal, no unlawful stays, nothing. And then they ask a simple question. They go, so have you ever used marijuana? Something to that effect. And the person will say, well, I tried it like 2 years ago and didn't really like it. Boom, they're inadmissible. Okay, something as simple as that, and then there's ways to get around that, but things like that happen. So first, I would need to make sure that no Walsh waiver is needed. So I'd need to ask you if you have any criminal history, assumably and hopefully the answer is no. Then I would have to ask your husband, does he have any criminal history? And I mean criminal history in his home country, in another country, in the U.S., wherever it is. Does he have any criminal history? And if so, what was the crime and what was the sentence? And then I would need to determine if a waiver is available. Okay, I would need to know if he's ever been here in the U.S. If he was here, how was he here? Was he unlawfully here at any point? If so, for how long? When did he leave the U.S.? Because I need to know if he's subject to the 3 to 10 year bar, and if he's already spent that time out, or if he needs a waiver for that. I need to know if he was deported while in the U.S., and if so, why. I need to know if he tried to get into the U.S. before and was expeditedly removed. There's all kinds of issues. I'd need to know if you make enough money so that he's not considered to be a public charge, things like that. Okay? Not to scare you in any way, but these are issues that need to be looked at. You can't just have him go to the consulate in a vacuum without checking to see if any of these issues exist. Now, sometimes what happens is it goes to the consulate and it stays there and it stays there, and then you do an inquiry and they say administrative review or administrative processing, and then it goes on and on. If it gets to that point, you can then file a writ of mandamus in an attempt to force them to make a decision to push it along. And that's the story of another video. But hopefully everything will go smoothly with that issue. Okay.